What I'm going to present briefly on now is law as culture and the need for cultural competences in international law. As Joshua mentioned, this is based on some of my PhD research and publications since then. I brought out 2 books last year, one of which Joshua mentioned, and the other is on law and culture at the International Criminal Court, which examines it in the context of international criminal law. And it was for that book project also where I worked with Joshua, who wrote a chapter in that volume. I'm going to start off with some caveats, though. I know we have perhaps a diverse audience of people here. And while my work is certainly multidisciplinary, I myself am a lawyer. I'm originally from Australia, where I worked as a solicitor. My main discipline in that sense then is legal. So I borrow and draw from some of these other disciplines, notably anthropology, but my main central focus is, of course, on the law. Another distinction that I see perhaps between EuroExpert and my own project is that my specialization is international law and institutions, whereas the EuroExpert project seems to me to focus a little bit more on the national legal systems. So what I've done is sort of borrowed from some of the ideas that I've taken from EuroExpert and seen how they are reflected in my research on international law and institutions. So that is going to be my focus of this presentation today. I'm not going to speak directly to the book that Joshua mentioned, but rather some reflections upon it and ideas that I've taken since then as well. So Joshua is going to give me the sign when I need to stop talking. And I'm pleased for that because I'm really looking forward also to discussions with the audience and debates about some of these ideas and sort of proposals that I hope to make. So thank you very much, Joshua, for keeping me in check there so that we can have a nice, fruitful discussion.
Of course.
The central idea, as I understand it, of the EuroExpert project is this notion of cultural expertise. And it's noted that it's not really a defined concept. And of course, culture itself is a highly contested concept as well. But I understand that the project uses cultural expertise as sort of an umbrella definition of different ideas. And my understanding of that is that cultural experts are persons who fulfill particular functions where they act as cultural brokers or as intermediaries or perhaps as vernacularizers. And that term, of course, I'm taking from Sally Engel-Merry and her groundbreaking work. And these sorts of translators, I argue, are needed in a range of situations, including interactions with the law and its institutions. And that is because the law itself, in my view, is or can be seen as a cultural product or part of a cultural process. So it's not in itself a neutral thing that is separate from culture, but rather intimately part of or even part of culture itself as a normative ordering system. I take in my research quite a broad understanding of culture itself, and I see it as including different modes of life, including languages, different value systems, normative systems, as well as traditions and beliefs. So taking this broad definition, then normative ordering systems, what I in Australia would call law, is a part of culture, and other normative ordering systems are also a part of culture. And here I'm thinking of also religious bodies of law or also customary law. So my interpretation of this is that really all of these ways of being and ways of regulating ways of being are part of our culture. And in Australia, of course, we have the common law tradition. So it's the British heritage. We wear the gowns, we still have the wigs as well. And the way I see the courtroom itself is in fact being a sort of theatre that is full of cultural symbols and practices. There are also, of course, modes of speech, ways of addressing. There's also the standing, the bowing, all these sorts of ritual practices that are very definitely part of culture, but also an inherent part of our judicial and legal systems. So the point I want to make at the outset is that the cultural expert doesn't bring culture into the courtroom. Culture is already there. Now, for those anthropologists or sociologists amongst us, you might be thinking, well, yes, of course. But this is news to lawyers. Lawyers are typically not trained in fields of anthropology or sociology, etc. And in contrast, are in fact often trained in the idea that the law is objective and is not culturally particular. So the idea is that law, aims to be objective and is neutral in this way, that it can be applied to all in a distanced way that's not subjective or culturally premised. And law and culture from this perspective are typically conceptualized as distinct realms of action that are perhaps marginally related to one another, but also potentially totally divorced. And many lawyers, I think, if you spoke to them today, and I understand that the project has a lot of empirical aspects to it, so we'll get this data from the project itself, but many lawyers might even suggest that law and culture are antithetical to one another. One of the scholars whose work I rely upon a lot, Abdullah An-Naim, has even argued that because culture is so deeply embedded in one's own identity and consciousness, that cultural codes can easily be overlooked or mistaken for being neutral or objective by those positioned within their frameworks. And this made a lot of sense to me when I read about this, and I thought, yes, of course, being an Australian now in the Netherlands, it gives me a great opportunity to reflect on my own culture and to understand all the things that I thought were quote unquote normal, that now I understand are actually culturally particular to Australians or to my local community in Melbourne, where I was raised and educated. And there's always the example that's given about a fish swimming in water, and the fish doesn't know it's swimming in water, it's just doing what it's always done. So it's this lack of awareness. And this lack of awareness, I think, can be problematic, especially when looking at national but also international legal systems, because there can be a tendency to then other culture as something that only others have. And I see this as sort of the Orientalist view. In Australia, it's typical to think that immigrants have culture, or migrants have culture, refugees have culture, but that the Australian system is sort of the standard, the objective setting, and the others are the ones with culture. And in this way, it's sort of, as I said, Orientalist, but also the exoticization of the other who has this culture. That's something that we don't have in our objective, known legal settings. And in my research, I found that international law frequently essentializes culture, so treats it both as something that's static and homogeneous, and oftentimes as an obstacle to international law's goals of seeing human rights and justice delivered. And this has come across in my research with some of the UN human rights treaty bodies. Joshua mentioned that I worked with CEDAW, which is the Convention on the Elimination of All Forms of Discrimination Against Women, and together with the committee overseeing the implementation of the Convention on the Rights of the Child, lots more acronyms and things here too. So that's CEDAW and the CRC. They put out a general comment looking at harmful practices. And this terminology of harmful practices is sometimes also said harmful traditional practices. And it's essentially code for female circumcision, early marriage, polygamy, and honor crimes. And it's the idea that traditional practices are bad for human rights, and that we need to address these cultures and change or transform these cultures to rid them of these harmful traditional practices. Something else I know that the project has also come in confrontation with is also the idea of the cultural defense, which in criminal law is particularly relevant, where somebody might seek to use culture as a way to justify or defend their actions and therefore not be criminally liable. So these are often ideas in international human rights or criminal law about the role of culture, is that it comes in this negative way that somehow needs to be modified or refuted in order to see justice delivered or rights upheld. These practices to me are also, I think, thinly veiled Islamophobia in many ways, because they often relate to Islamic practices. And I think that that relates more generally to fear of veiled women in the West, and these sorts of discourses that we're sadly not so unfamiliar with. I also think that these examples show then perhaps Islamophobia, but also a bias against the global South. And this informs my argument of culture and othering, the othering of culture as also a form of Orientalism, perhaps a contemporary form. And it's here where I say that culture is, of course, ubiquitous. It's not just something that others have, but it's something that all nation states and peoples have, and all legal systems also have. All legal systems in the world are culturally coded and are not neutral or objective in and of themselves. And I think this sensitivity to this cultural diversity is reflected in some ways in international law. And an example I can give you here is in relation to the European Court of Human Rights, where a case comes before a particular state, say the Netherlands comes before the court. And in that situation, on a judicial bench, so in the chambers or the Grand Chamber, the Dutch judge will always be present in those cases. And this is perhaps a way to provide a source of cultural expertise in the deliberation of that case, because the Dutch judge knows the Dutch legal system, knows the Dutch national system, knows Dutch culture, and is able to perhaps provide some of that translation or that cultural expertise to their fellow judges to aid the decision-making process. But it also perhaps aids in legitimacy of the court's decision, because it's seen to be not something, delivered from beyond, but rather including also a Dutch person or a Dutch national at least, that gives some sort of legitimacy to the court's decision. This idea is reflected also at the International Court of Justice, also here in The Hague. And before that body, a state with a complaint before the court may appoint an ad hoc judge, if there's not already a judge from their state on the bench, if there is a contentious case about them before the court. So this is either an ad hoc judge, which is additionally appointed, or a pre-existing judge is given to that bench. And again, this idea is really reflecting that idea, I think, perhaps of legitimacy, that the decision will seem to be more legitimate and less biased or less politicized than if there wasn't a judge from that state involved in the deliberations and decision-making. However, the opposite is also true. So the examples I'm going to give are again in relation to the UN treaty bodies. These are the human rights treaty bodies and the International Criminal Court. Because before the human rights treaty bodies, national representatives are excluded from deliberations about their own state in order to avoid perceptions of conflict. So there may be actual conflict, or it may simply just be a perception of conflict, but in any case, the person who is a national of that state recuses themselves in those deliberations. Now, there are some distinctions here, which of course the lawyers out there will point out. Human rights treaty bodies aren't courts, they're rather quasi-judicial bodies. They don't give legally binding decisions. So perhaps that plays a role. Also the fact that these bodies typically have geographic representation. So perhaps there is also this cultural sensitivity built in by the fact that all regions of the world are represented, and therefore that person's insights are not as needed. So this is also then an interesting tension, where you see that in some of these international or regional bodies, the idea of a national judge is seen as a good thing because they can aid decision-making. But then in other situations, the idea of a national judge is actually seen as a source of illegitimacy because of perhaps this perception of conflict. So I see that there being both a funny position, whereas on the one hand it aids legitimacy, and on the other hand it can be seen as a source of illegitimacy. So I see that as a point that actually I think would deserve more research. And it makes me think then, in the context of international criminal law, at the International Criminal Court, for example, the judges there, typically by practice, will not sit on a case regarding Mali if they are from Mali themselves. But this makes me wonder, should the opposite practice not be taken up, where rather the judge from Mali should sit on that case, so as to also give legitimacy to the Malian state, to Malian people, and play that role of cultural expertise? So that's a question, that's a thought that I would like to propose. Now, the ICC, I think this is really relevant for the ICC because they do need very much those sorts of cultural insights on the bench. And typically they have done that to this point in time via cultural expert witnesses that have been called to give testimony. And the ICC desperately needs this because they are based here in The Hague, as I mentioned, and they have a wide variety of cases from different states in the world. So Mali, as I mentioned, but also the Democratic Republic of Congo, but also investigations in Georgia, Afghanistan, and Bangladesh. So to deal with this huge cultural diversity, the ICC does have a team of linguists who help with the translation of, well, court interventions, but also all written documentation. But they don't do that cultural translation or vernacularization. So this is still then a gap in expertise that is desperately needed. So that's one way where we're informing the court of local cultures, but what I think is also necessary is for the court to have some sort of cultural expert to translate the court for local communities, because it is a huge task for the International Criminal Court to go to local affected communities and endeavor to explain the idea of international criminal law, the idea of international criminal justice, and the court and its processes to these local communities. And this is where I see the idea of cultural brokerage being a two-way system. So it's not just giving information to the court about a particular cultural community, but also giving that cultural community information about the court itself. And this is where I like to draw from Sally Engel-Merry and her idea of vernacularization, because she sees that as a two-way flow of information, both back and forth. And in this sense, I think it also plays really nicely into ideas of legal pluralism and the idea of this commingling or interaction of different normative ordering systems that then also influence and inform one another and the norms within both of those systems. And I don't see this evolution or this dynamism as problematic because law, like culture itself, is also dynamic. And certainly international law is a very dynamic body of law. So this two-way flow and the ability of international law to see itself in the local and vice versa is also particularly important for international law because it seeks to be universal. And international law, I argue, cannot be universal if it does not reflect or include all of the various cultures from around the world. And if any particular culture is excluded or rejected by international law, then international law falls short of its claim for universality and also therefore legitimacy. And this is where my research comes in, because I've looked at the substantive overlap of different normative systems, as well as the dialogue at various levels. So the local, the national, the regional, and also the international. And I argue that there's actually much scope at the international level for greater awareness of culture and greater respect for cultural diversity. I think I have a couple of minutes left, Joshua. So I'm going to give you some examples.
You have 15 minutes left, don't worry.
15? Oh, it's loads of time. Okay, great. So I can go into some of my examples then, which are always the juicy parts of these talks. So I will give you some examples from Indonesia, which is where I did my field research. The examples relate to these bodies that I discussed before. So the UN treaty bodies, this is the Committee on the Elimination of Discrimination Against Women. And it also relates to the Committee on the Rights of the Child and also the committee overseeing the implementation of economic and social cultural rights. So back to these harmful traditional practices. One of them is female circumcision or female genital mutilation. Different names, I think, demonstrate your approach to the practice. In Indonesia, it's a widespread practice, high prevalence of the practice. It falls under the World Health Organization's definition of female genital mutilation. It would be the category, the lighter quote unquote category, where it's usually done typically to babies right after birth, and it's seen to be more of a pricking rather than a cutting, a removal, or sewing of vaginal tissue. But despite that fact, whether it's light or not, international human rights law has taken a zero tolerance approach to female circumcision and said that all forms of its practice are a human rights violation. So the various human rights bodies have been calling upon Indonesia for years to criminalize female circumcision, which is widespread there. They've also been calling on them to also prohibit other practices, including child or early marriage. So Indonesia gave in to some of this pressure and they decided to prohibit female circumcision. However, in response to this prohibition in national law, there was a huge domestic backlash. And in fact, several fatwas were issued against the prohibition by the government of the practice. Female circumcision in local Indonesian language is actually translated as Islamic female practice. So it's very much seen to be a practice that is linked to Islam. And Indonesia is, of course, the world's largest Muslim country by population. So the government's legislation was not popular and revoked, was actually revoked based on the backlash of the public and these Islamic rulings against their prohibition. So that really shows that despite the human rights law position and despite the work of these UN treaty bodies, Indonesia wasn't able to actually pass legislation prohibiting the practice, nor to implement it or enforce it in any way because of the cultural norms and because of the fact that it was widely seen by Muslims to be a religious requirement, and it was seen to be permitted by the religious leaders. There are a number of organizations in Indonesia, large Muslim organizations called Muhammadiyah, and also Nahdlatul Ulama, who were both saying that the practice itself was permissible within Islam. So here we had a direct confrontation then between the government and also then these religious organizations and these Muslim leaders. And these organizations are huge. They have over 150 million members across Indonesia. So they are very powerful sorts of organizations. In relation to child marriage, the Indonesian government did not prohibit the practice, despite, again, calls from the international level and the charge that it also was a violation of international human rights. Both these practices have been widely debated in Indonesia for decades now. These aren't new topics. And there has been vigorous debate in Indonesia about these issues, also from the perspective of international human rights law. And again, these organizations, Muhammadiyah and Nahdlatul Ulama, and the religious clerics at the top of those organizations said that child marriage, like female circumcision, were permissible. And this was despite debate both with government, with other Muslims, and with other Muslim organizations. So an interesting part here then is that in 2017, a group of female religious leaders came together in Java and held a meeting at which they pronounced their own fatwa on the issue of child marriage. Fatwa is a religious ruling. It can be in support of something or it can be against something. And it is a religious ruling that's not binding. So it's not law per se. You can't go to court or enforce it as something like this. But it is very powerful and it can be seen as very authoritative for Muslims who follow those leaders and their various fatwas on different issues. But this particular fatwa was remarkable because it was made by female Muslim leaders. Typically, Muhammadiyah and Nahdlatul Ulama are led by the most senior clerics who are typically men. So this was a really important initiative where female religious leaders came together and undertook their own analysis of religious law and Islam and said that based on their understanding, child marriage wasn't permissible in Islam. And then, coincidentally or not, just the next year, the highest court in Indonesia ruled that child marriage was also impermissible. And in doing so, both the court as well as the female ulama, the female religious leaders, referred to international human rights law as well as course of religious texts, etc. The courts, of course, also ruled based on Indonesian national law. But it's really interesting to see then that this prohibition on child marriage has actually come about through some of these religious norms and also through the judicial system, but not then through the legislative system. And I argue that the treaty bodies, particularly in this case, the Women's CEDAW Committee and also the Committee on the Rights of the Child, should accept these different cultural processes and the different value of these different cultural norms and see them as being, potential assets in implementing international law and finding respect for international law, and not only viewing these different cultural actors and different cultural norms as obstacles to rights or justice. And so this, I think, is perhaps another job for this project of Euro Expert and another job for cultural experts, to be talking to these UN committee bodies and actually being able to vernacularize or to be intermediaries to translate up and down how the culture works in these particular settings and how international law is to be implemented in a way that both respects international norms, but also then local norms and cultural processes. I also think that there is huge scope for this at the International Criminal Court. There is a case right now before the International Criminal Court that relates to Mali. Mali is, of course, a Muslim majority state. But more than that, the case actually relates to a Muslim who was involved with the Islamic police and an Islamic group. And so it's highly relevant to look at Islam in this context. So I think the court is not going to be able to avoid it in this situation. And so I think it is a really interesting opportunity and case study to look at the role of cultural expertise and how the court uses it or engages with these cultural norms in determining the criminal liability of the individual whose name is Mr. Al-Hassan. Now, I think this is a bit of a test case because I mentioned other cases before the ICC or situations which include Palestine, but also Afghanistan. It also includes the Rohingya from Bangladesh, Myanmar, and also cases from Sudan, which all involve Muslim majority states. So I really think here that the International Criminal Court should take up this challenge of really engaging with cultural experts, really engaging with cultural norms, in this case, Islamic law and institutions, and not distance itself from those norms and not see them only as obstacles to their processes, but an integral part of their processes and delivering justice to those particularly affected communities. So this is my sort of challenge to the International Criminal Court. And one of the suggestions has been whether or not there could be a judge on the International Criminal Court who has expertise in Islamic law, and whether or not that would be seen as something that was welcomed, given that Islam is one of the world's legal systems, or whether that would be seen as, overtly cultural, and perhaps also rise some backlash in relation to Islamophobia, perhaps. But these are interesting ideas that I think should be discussed. I also think it's really important. My research is really focused on Islam and cultural systems there. But that's also because the growth of Islam around the world and the Muslim population is seen to be increasing. And it is projected, in fact, that this population will take over the population of Christians around the world as the world's largest religion. We've seen across Europe as well also a growth in the Muslim population. And I think it is really important to engage with these norms, with these cultural systems and these different ways of knowing. I think on 2 points, and I'll conclude here. One is from a principled position that we should respect people's freedom of culture and religion, of course. But also, I think it makes international law more universal and also more effective. So I think both of those two reasons are compelling reasons for us to indeed take up and engage with different cultural experts who can help us navigate between these different legal systems and legal settings.
Thank you. It was very, very, very interesting.
I feel like I talked for a long time.
No, it was perfect. Actually, you were under And so now we have more time for question and answer, which we
Great.
will be opening up the floor. If anybody has any questions, you can go ahead and use the question and answer feature at the bottom of the screen and pose any questions. I actually have a question I'd like to ask. Kind of involves both, questions of the book that you had written about Indonesia, as well as some of your ideas on international criminal law. You had written in a chapter of a book where you kind of discussed some of the parallels between international criminal law and Islamic law, and how some of the ideas actually translate. But when I also was reading your book about Indonesia, you very much talk about how you translate the ideas to kind of establish almost a preemptive way to communicate to the culture that this is already within your cultural system to follow from the beginning. Is there a way to then translate in a preemptive way international humanitarian law or the laws of war so that the ICC will already have a footing when it is involved in a case, instead of having to prove, or at least have cultural experts come in, translate what's going on the ground for the court, and then translate it back to the people as well?
Yeah, it's a really good point. And I like that you picked up on that two-way dynamic, because I also sort of buckle at the idea of this very top-down international law system where it's unidirectional, and it's sort of seen as, the superiority of norms that have to be communicated downwards. And I do very much believe in this this dialogue between these systems and development of both bodies of law. In relation to Islamic law and IHL, humanitarian law, I think it's really important because we have all of these situations from Islamic states or Muslim majority states before the International Criminal Court. And that's because there's so much armed conflict in Muslim communities. The Red Cross, Red Crescent, the ICRC have said that 2/3 of their work nowadays is actually in Islamic contexts. So I think it's even more important to also be looking at the norms on the ground from religious groups, and also then how international law either aligns, as you were talking about, or doesn't with those norms. And it's also important because a lot of these armed groups in these Islamic contexts even use Islamic norms themselves to help justify their violence. So Sharif Bassione has said that this is really important, and we're actually obliged as Muslims. He's a Muslim, I can't speak from that perspective, but he was saying there's also an obligation to push back against those interpretations and not allow those interpretations to stand as or to claim legitimacy and authority within Islamic law. So I am pleased to say that the Red Cross, the ICRC, is actually engaging with Islamic actors and Islamic norms, and has done a lot of work at this idea of sort of translation, as you say, in terms of looking at compatibilities. And I also know Muslim scholars as well who are looking at the laws of war and are also looking at how Islamic norms would apply to contemporary conflicts today. So if obviously Islamic law is centuries old, but they're saying, what does Islamic law tell us about, for example, the modern use of drone warfare or chemical warfare or something like this? So there's also the ability for Islamic law to evolve and to develop in that way, just as international law is also dynamic.
Thank you. We have a question right now from Noura Arjavari. You can go ahead and ask your question.
Hi, yes, I'm Noura Arjavari. I'm actually working on the Euro Expert project at the moment. Thank you, Julie. It was fascinating presentation, and I think it links in many ways to my work as well. I have quite a specific question regarding custom and customary law. So I have written on customary international law, but how does customary law, local law, appear in international courts and tribunals in your experience? I mean, this is something I really have not looked at because I focused really only on the international customary international law. So I would be curious to hear if you have encountered application or interpretation of customary law. Thank you.
Thanks, Nora. Yes, I saw your profile on the website. It's nice to meet you. The question of custom is also a great point. And the ways in which I've seen that arise would mainly be from a human rights perspective. And that, again, in relation to women's rights, an example I could give would be adat law from, again, Indonesia, where, for example, in terms of inheritance, they would have particular laws saying that inheritance flows through a particular line. And that might be challenged under international human rights law based on equality in terms of where inheritance is diverted from the female lineage. So issues like that have come before the UN treaty bodies. And there are then arguments about equality. And of course, in those sorts of situations, they would say, well, that's a violation of equal rights or women's rights in this context. And that customary law or adat would also then have to shift. And again, in that sense there, it's always these examples of custom or these different practices that are in violation of oftentimes women's rights. And we see that in relation to marriage, so family law particularly, which is also inheritance is part of that as well. So I would suggest that it comes before the UN treaty bodies via individual complaints, perhaps. There's also been one from that came before the Human Rights Committee of the UN by Canada in relation to an Indigenous woman who was dispossessed of land within her Indigenous community because she married out of the community. And there again, you see this question of the application of customary law being overturned because it would then be considered to be discriminatory against women. So in individual cases like that, so individual complaints, I think notions of customary law have come before the human rights treaty bodies. And also in terms of general reporting and concluding observations, the human rights treaty bodies have dealt also specifically with custom, where it is allegedly or arguably discriminatory against women. I hope I've answered your question.
We also have a question from Tiki Manakoso. You can go ahead and ask your question now.
Yes, good afternoon. The presentation is very brilliant. I'm very happy to listen to you. I'm a journalist based in Geneva and I have followed the CEDAW for many years now. And it's very interesting to think about the fact that the international convention should be maybe universal, but one of the points is what will be the standard that will be accepted at the international level when you have at least 200 countries, and even in the same countries you have hundreds of culture for the same issue, and it will be a little bit complicated. The second issue that I would like to raise is that, for example, Africa has a tradition of what they call African humanitarian laws, but I will just give you an example. It was that in case of war, for example, they will take a girl from one ethnic group who will marry the chief of the other ethnic group or the queen of the other ethnic group to have peace. But at the same time, this is a forced marriage. If they have to take a girl from one part to another just to have peace. And when the African are explaining it, they are saying that in our tradition, we are not killing women, we are not rape women, we are giving them to marriage so that the woman was like a sort of, a sort of person who will help for mediation, because by the time that this woman is married to another ethnic group, they have a sort of proverb like you cannot fight, you cannot go to fight where your heart is already conquise. I have to probably say it in French. On va pas faire la guerre là où son cœur est déjà conquis. So that when the chief taking the wife, the girls of another ethnic group, they will stop war. So it's a little bit complicated. Thank you.
Thank you very much. Those are both great questions. If you've been following CEDAW for a long time, you probably know it better than I do. I don't want to make out that it's an easy process. You've said before, what should the standard be at CEDAW? There are 200 states that they have to deal with. And within that, there's of course, huge diversity within states. And Indonesia is a perfect example of that too. Hundreds of millions of people, huge diversity across the many different islands, a Muslim majority, but still so many differences between that. and different mixes. Even the two examples of the Islamic institutions I talked about, Muhammadiyah and Nadlatul Ulama, one of them sort of aims to reform Islam to be more focused on sort of Islam strictly from the sources, whereas Nadlatul Ulama is more focused also on local customs, Javanese customs and culture. So it's also then a mix of kind of the local cultural norms influenced then also with Islamic norms. So yes, it's not an easy job, and I don't want to pretend like there's a simple solution for this. I'm not jealous of the work that those committee members have to do, but I think we can still do what we're doing better. Now, there's a number of caveats that have to apply here, of course. The experts are unpaid, the experts have limited resources, the UN at the moment, the High Commissioner's office is particularly underfunded. So all of those things apply. But I think we shouldn't be afraid to engage with culture, to call it culture, to name the different actors that are involved, the different norms that are involved, and to realize that universal human rights law doesn't have to be uniform in practice, so that there is going to be a standard of equality internationally, but that might look slightly different in practice in different places, and that can be okay. And that actually international human rights law accommodates diversity in a number of ways. There are a number of different mechanisms by which international law can actually accommodate this diversity. And we should take up that challenge and not shy away from it, I think. And I do think that the CEDAW committee does do better here than some of the other committees. If I'm looking at the Human Rights Committee, I think CEDAW does a much better job at that than they do. And the same also with the Committee on Economic, Social, Cultural Rights. They also take sort of a much more legalistic approach to it that doesn't as much engage with cultural norms and actors within the states that they are supposed to be examining and monitoring. Your second question then related to African humanitarian laws and the marriage of girls across tribes. Yes, there are definitely, so just as much as we have like Islamic laws of war, there's of course also various African traditions. A colleague of mine is doing her PhD on that at the moment. And I think that we need to embrace this legal pluralism and look at all of these different norms. Everybody, I think, has recognized that international law is not perfect, and it is a project that needs improving. And I think we can take ideas from these different cultural systems to improve the law, both in terms of the substance of the law, but also then the universality of the system itself, which is a bonus. So while I suggest, yes, there's a lot of overlap and a lot of compatibility between customary norms, between religious norms, national and international law, there are, of course, examples of violations per se or conflict. And this example that you gave then of forced marriage is perhaps one of those. And in these situations, I suggest a process that is still a bottom-up process rather than a top-down one. So instead of saying, this is international law, this practice is in violation, it must be criminalized or done away with, but rather we still use the local cultural norms in order to discuss and reshape and reform those local cultural norms. And that's a job for local cultural actors and not, international treaty body members, for example. And there's a brilliant scholar, Celestine Niamu, who's given several different examples of this from Kenya. And she's looked also at inheritance practices, land ownership, these sorts of things. And she says that in any situation, there's going to be a diversity of practices on the ground. So you may have one particular norm that's articulated, but there will be a variety of practices that won't all be exactly the same. And this variety of practices also shows that there are different ways of interpreting and applying a norm, and ways in which women, in her examples, can still inherit or claim land or claim ownership or access to land. So I would suggest that in terms of looking at this practice that you were mentioning, it would really be something for that cultural community to look at in terms of how, or if they are going to, and if so, how they can transform that practice. There are many different ways in which culture shifts over time. This is part of the dynamism of culture itself. And that dynamism can be used as a mechanism to also change and shift these cultural practices. And this isn't just, in African communities, but also in Western communities all around the world. Culture itself is dynamic and changing. So they are our norms. We are agents within our cultural systems and can shape them. Now that then, of course, opens up a big question about power dynamics and who can access agency or has different agency and authority in different ways. So you, of course, have to be also interested in those different power dynamics, but we are cultural agents within our own context and can shape those norms to be more in line with our international goals of human rights and justice.
Okay, thank you very much. We also now have a question from Naeem Akhtar. Please go ahead and ask your question.
Hello, thank you for it was really thoughtful. I have a question, to what extent Islamic law and international law are compatible? When you look the Muslim world, they believe religion first, then society. Whereas sociologists believe in society first, then religion. So under these conditions, to what extent Islamic law and international law are compatible? Thank you very much.
Thank you, Naeem, for the question. Thanks for raising this issue. In terms of, so I'm not an Islamic scholar, so I'm not going to go through and be able to tell you all of the different ways in which they are not compatible. I am an international law scholar as a first caveat. But there has been a lot of studies done looking at this question of compatibility. Compatibility of human rights norms, for example. There are a lot of scholars who have dedicated their careers to mapping out the overlap, the compatibility, and also any points of contestation. In human rights law, these are typically related to questions of women's rights, also issues of apostasy, religious freedoms, for example, and some punishments also. Those are the typical examples that are given in relation usually to human rights law. Scholars have also mapped out the overlaps then in relation to humanitarian law. As I was mentioning in relation to Joshua's question there, the Red Cross is actually looking very closely and has engaged Islamic scholars to do those studies. The same thing with international criminal law. There are also scholars, Islamic scholars, international scholars mapping out the overlap and the compatibility of those branches of law. I've also got a book on my shelf of a scholar who's done so in relation to environmental law as well. So I can perhaps give you some sources there if you're interested really in looking at the compatibility of all those different branches. One thing I will say about Islamic law is that they also have this similar conception of international law that we would call international law. It's called siyah. And part of Islamic law also says that as a Muslim person in a particular country, you are also obliged to respect the laws of that country. So in terms of looking at hierarchy of norms, there's actually a lot of sophistication in Islamic law in terms of recognizing other legal systems, as well as national, but also international legal systems. You talked about religion first or society first. With Islam, it's interesting because it's a complete system. So it's also a political system as well as a legal system. So I don't think there you would perhaps have such a differentiation between ideas of society and religion. I think religion there also maps out rules between Muslims, between non-Muslims, and then relationships with God. So it's really quite a comprehensive system there that I can't pretend to speak to all the different issues there. I mentioned before the idea of having an Islamic scholar as a judge on the International Criminal Court, and that's also been debated, that point that you raised about hierarchy. Would such a judge apply international law as the highest authority or Islamic law as the highest authority? And I think here that would depend on the judge. I think that would depend on their interpretations of the law and where they see overlap or any differentiation. Where they would be called upon to perhaps give a difference. But many of the scholars in international criminal law, I'm thinking about Sharif Bassioni here, were in fact also Muslims. and they were able to influence greatly the development of international criminal law without obviously having it be a conflict for them in terms of their own religious convictions and affiliations.
Thank you. That was actually very well said. We have a question right now from Cornelia Weiss. You should have the ability to unmute yourself. Go ahead and ask a question.
Yes, thank you very much. I heard you advocating for individual complaints, and I'm curious as to how individual complaints can be made when the state prohibits, either through non-ratification of optional protocols or via reservations, their citizens from submitting individual complaints.
Thanks, Cornelia. Yeah, it's an important question. Of course, some of the treaty bodies have much more jurisdiction than others do. The Human Rights Committee, I think, being one that has a large jurisdiction, but certainly others, including the optional protocol for the International Covenant on Economic, Cultural, and Social Rights, is very new and has very few ratifications. The same thing also with the Convention on the Rights of the Child, and their individual complaint mechanism is also new and under-ratified. There's also then the added problem there that even if you manage to get an individual complaint through a national system, then up to the international system, and then a decision by the treaty body on the merits of the case, it's also the issue, of course, that the decisions aren't legally binding. So it is indeed highly problematic. And of course, it's going to take years to go through that process. So it's also not a swift remedy for victims in any situation. It can still be important, of course, and the precedent that sets and the jurisprudence, etc. But no, it's certainly a very difficult process for victims, even if a state has ratified the optional protocols and given jurisdiction to the treaty bodies to make those individual complaints. It's very difficult. It's also very unknown. I know even in Australia, there's very limited knowledge of these procedures and what can actually be done. Most of the cases that go to that level are strategic litigation that has been sponsored by NGOs or different organizations for a particular purpose. So I wasn't necessarily advocating individual complaints. I think they are highly problematic in some ways, but it is an important way in which these treaty bodies do develop and specify what the law is in relation to particular circumstances. So that would be my answer there.
Thank you. We also have the question right now from Chor Swain. You should have the ability to unmute your mic now. Please go ahead and ask a question.
Hello, thank you so much for really fascinating and informative talk. I really appreciate your work. So I'm an anthropologist and also part of Euro expert. I've been working with asylum seekers from Asia in the US. I go to court and represent them as an anthropological expert witness. So I work with lawyers. I think in the US, we have issues you have touched on. So my work is trying to translate both up and down. So my question is, how do you prevent or how do you include the multiplicities of any group or any culture or any nation? So let's say we do include, you mentioned that just now, include somebody who is a Muslim on a panel. If there's only one Muslim, you have to guess which position does he belong to, right? So how do you, it's not just based on religion, but based on culture, because they are nationalists among cultural groups. And if you include race, the word race doesn't correspond to almost anything except for skin color. But yet we have used race as a category. And so the recent conversation in the US after Black Lives Matter is about white privileges. But I'm not sure if people are still uncomfortable with that term. So does that word privilege creep into the idea of, you know what, I'm a Buddhist or Islamic scholar, I have this privilege based on a certain tradition. So how do you deal with that? How do you include and respect that multiplicities, especially in conversations with individuals, if you do not know of their writing or their publications, because these are the people you're going to influence every day in your work.
Thank you, Choi Swang, for the question and also the comment about your experiences in the US. Again, I think it relates to the earlier point about the difficulty of this process. And I'm not an anthropologist or an expert in that sense. And I know that there are experts there who are working with these different issues. And I would call upon their expertise in terms of actually doing that sort of work. But a point that you raised, I think, is also really important, particularly in the US, looking at privilege, but also asking questions about who is on the bench, and does the judiciary actually reflect society in terms of the makeup or the composition of that society, in terms of, yeah, skin color, religious beliefs, linguistic abilities. Generally within the law, it seemed to be a fairly prestigious field. It seemed to be a fairly elite field. It is difficult to access in many, many states. I'm talking for myself about Australia, the Netherlands, the UK, the ones I know. And they are also very unrepresentative of the societies that they serve. So that includes lawyers, but it also includes judges, legal practitioners, etc. That they are, in fact, typically male dominated, and typically, at least in those countries, also made up of individuals, usually from a Caucasian background. And this is, I also see, is part of the problem and part of the blindness, where I know in the US they talk about, being colorblind, and that's now seen to be the idea that you're actually not aware of the differences and the diversity, or sensitive to those differences. And so I think there has been a bit of a shift in the US around some of that language, into this understanding that there's a lot that the majority need to actually understand about other cultures and other people within their own communities. Living in Amsterdam as well, I found out recently that Amsterdam actually has a majority of people from an immigrant background, or, well, like myself as an immigrant. And that there's more of us than there are sort of Dutch-born, heritage people. And so somebody was suggesting that, in Amsterdam, there also needs to be cultural expertise, because, you're going to have to engage in a very multicultural setting that isn't majority traditional Dutch culture. And I think that I would advocate that we also have national legal systems that really do reflect the national populations, and that are made up of all sorts of different people in terms of ability, or persons with disability, but both men, women, sexual orientation, etc. And I think this lack of diversity on the bench is also part of our problem, and why we need cultural expertise.
Thank you very much.
Yes, thank you. That seems to be the questions we'll be taking from the audience. I do, however, have one last question that I would like to pose. As I was listening to your presentation, and as well as some of the discussions you had in the book, one of the questions that popped in my head was, you frame this in trying to convert these laws into kind of a local context, into a local system to be able to translate. What about within systems that is not necessarily based on a religion? What about political cultures, or things that aren't so easily translated, where, for example, in the United States, you have more right-wing dialogue that just shuts down, for example, international human rights, refuses to participate in the Convention on the Rights of the Child, or CEDAW. How would you suggest, is there a place for cultural expertise to be able to mediate here?
I think so. Don't get me started on the US, because that's a tough one. And we're recording. But no, this is precisely where I think we need to be going back to cultural expertise and relying on cultural norms that have legitimacy within those communities, and are more likely to shift those communities than outside norms that don't have that same amount of legitimacy. There's an example from a scholar called Rifat Hassan, who said, my project was in relation to reproductive rights. And Rifat Hassan wrote, and she said that a Muslim woman is much more likely to believe that she has reproductive freedoms based on the Quran rather than telling her that a UN document will set her free. And I think the same applies in the US. You need to talk to those particular groups based on their cultural norms and use their cultural processes in order to engage in that dialogue. And that again is part of respecting cultural norms and practices and the diversity. And I think then just insisting that this is international law and must be complied with is not going to get you very far.